Right, so we have done the three lines of defense. Now we take a look at the paragraph 2 very quickly. So I do not want to belabor the point, just to mention that in terms of the connected party at 2.2, all right, so this guideline sets out the examples of natural persons with executive authority in the company. All right, so the natural persons with executive authority in a company include chairman, chief executive officer. An example of a natural person with executive authority in relation to a partnership is the managing director. Okay. Now, 2.3 is a little bit difficult, so I need you to follow a bit closely. All right. Now, when performing customer due diligence measures in the scenarios below, all right. Now, this cannot be found in the notice. It's not found in the notice. So they give you two scenarios, all right, whereby you have to do customer due diligence in the way in the way this guideline provides for you, right? So A is portfolio managers. Right? A financial advisor may encounter cases where, to his knowledge, the customer is only a manager of a portfolio of assets and who is operating the account in that capacity. The customer is only a manager. Right? In such cases, the underlying investors of the portfolio shall be beneficial owners within the meaning of the notice. So how, in this particular case, where the customer is only a manager of a portfolio of assets? Now, however, the authority recognizes that the financial advisor may not be able to perform CDD measures on the underlying investors. Right? For instance, the portfolio manager may be reluctant for commercial reasons to reveal information on the underlying investor to the financial advisor. Right? In such circumstances, the financial advisor should evaluate the risks arising from each case and determine the appropriate CDD measures to take. Now, generally, the financial advisor may consider whether the simplified CDD measures under paragraph 7 of the notice should apply. All right, especially when the customer falls within paragraph 6.15 of the notice. All right, now if you refer to 6.15 of the notice, which we have talked about much earlier, these are exempted from making inquiries about the existence of beneficial owners, right? The existence of underlying investors. Therefore, the financial advisor does not need to identify and verify such underlying investors, right? In a scenario where your customer is a portfolio manager. Right? Now, very quickly, I give you some time to take a quick look at 6.15. In fact, 6.15 refers to Appendix 6 of this particular chapter 6. Right? Now, take a quick look at the 6.15, which refers to Appendix 6. All right? Where Appendix 6 sets out the customers where there's no need for you to make inquiries, whether there are any beneficial owners or of the underlying investors, right? So I give you some time. Let's take a look at Appendix 6. Right? Now, we have referred to this earlier in my discussion with you on the notice provision governing money laundering and terrorism financing. Now, if you look at Appendix 6A, I will read to you this again. Financial institutions that are licensed, approved, registered under that particular paragraph to the second schedule, right, do not include, right? So A and B, holders of stored value facilities as defined under that section of the Payment Systems Oversight Act, or a person under the paragraph 2 and 3 exempted from licensing under section 15 of the Trust Companies Act, right? They do not include those persons. All right, and also persons regulated under section 23(1) of the Financial Advisors Act, and paragraph 3 there, persons exempted under Section 99, 1B of the Securities and Futures Act, and read together with paragraph 7.1b of the second schedule to the Securities and Futures Licensing and Conduct of Business Regulations. Right? So all others are included except for 1A, B, and 2 and 3, where do not include. Right? Now, for the avoidance of doubt, the financial institution set out in Appendix 6B fall under Appendix 6A. You turn the page there, you see the Appendix 6B. So these are the institutions from 1 to 12, which I referred to you earlier, in relation to the fact that they are exempted, right? So if your customers are from that group of people, 1 to 12, then there's this exemption from making inquiries about the existence of underlying investors. All right, so in relation to a customer who's a portfolio manager, and for that customer, which are related to the paragraph 6.15, also Appendix 6, then in other words, you are fine, right? In terms of conducting CDD measures. Now, the second point is important for you to note as well. So in a scenario where the location of the relationship management is concerned, right? Now, given the globalized nature of modern financial advisory business, it may be the case as a scenario that a financial advisor's relationship and transaction with a particular customer is managed by a financial advisor, employee, officer, or representative based in one country or jurisdiction. All right, the management by a person is in one country or jurisdiction, but the account itself is held with an office in another country or jurisdiction for bookkeeping purposes. So here you have two distinct functions in two separate jurisdictions. Then the question is how? Okay, in terms of performing customer due diligence, right? Well, the guideline here provides that the authority will generally look at the substance of the relationship as a whole. Right? So on the one hand, all right, the transaction, the relationship, the transactions with a particular customer, it's managed by an employee officer based in one country or jurisdiction. But the account itself is held with an office in another country for bookkeeping purposes. So again, there's this issue. So MAS is going to look at the substance of the relationship as a whole. And the financial advisor should perform the applicable CDD measures if, in substance, the relationship or account is managed by an employee, officer, or representative of the financial advisor in Singapore, even though the account is booked in another country or jurisdiction. Right? However, the financial advisor may rely on the CDD measures carried out by its related entity in the case of a branch network, right? Another branch of the financial advisor in accordance with paragraph 9 of this notice. Okay. So these are the two scenarios whereby the guideline is provided to you in terms of the approach you can take in conducting customer due diligence. Okay, so these 2.3a and b, please take note. Right? In terms of CDD measures for anti-money laundering and anti-financing of terrorism is concerned. Right. Now, this notice at 2.4 and 2.5 give you certain clarifications as well and examples. All right. In terms of, for example, 2.4, what is a legal arrangement, right? So in relation to a definition of legal arrangement in the notice, here they give you some examples, right? Include a trust, a fiducie. Now, fiducie is a French word meaning a trust relationship or similar relationship. It's a French word, all right? Then Treuhand. Now, Treuhand is a German word, right? Treuhand simply means some kind of an agency relationship, right? These are legal arrangements, right? And then fideicomiso. Now, fideicomiso is actually a Mexican word. It relates to a bank trust, right? So some kind of a bank arrangement. There's no need for you to worry too much about the actual workings of these agencies, right? Just to know that these are all legal arrangements, all right, insofar as a customer is concerned. Right? So you have got trust, you have fiducie, you have truhan, and you have fidei cos miso. Now that's in terms of the definition for a legal arrangement. Now in terms of a legal person, the guideline here also gives you some examples, right, of legal persons, and they include companies. Obviously, a company is a legal person, it's a legal fiction. Bodies, corporate, foundations, and they also have a word called Anstalt. Now, Anstalt is again another German word, all right. Anstalt simply means is a kind of hybrid company, all right, with shares in a foundation or an institution or a home, right? It's a German word for a legal person, Anstalt. Right. Then 2.6 is self-explanatory. Officers will refer to the board of directors and senior management. Okay. And number 4 sets out the thing regarding risk-based approach, which I've emphasized. So again, it is self-explanatory, so I do not want to go into the details there. All right. 4.2 talks about the relevant authorities in Singapore, which you already know, like Singapore Police Force, Commercial Affairs Department, the CPIB, the Corrupt Practices Investigation Bureau, in terms of corruption. All right. So corruption, as you know, is a key part of the prevention of money laundering and countering financing of terrorism. So CPIB is responsible for looking at corruption charges or corruption allegations, right? And of course, other government authority, the Attorney General's chambers, this is the AGC, is a government lawyer, as it were, and it also prosecutes criminal offences. Right? So if a person is charged with money laundering or terrorism financing, then after investigation by the police or by the CPIB or by the CAD, then the matter will be referred to the AGC, the Attorney General Chambers, and generally the AGC will prosecute that person either in the district court or in the High Court. Then you have Ministry of Home Affairs and the Ministry of Finance and the Ministry of Law. All right, so these are the relevant authorities, right, relating to money laundering and countering the financing of terrorism. Okay? And of course, you also must have, you must also understand in terms of FATF and the other international bodies, right? Because of International Committee, COMITY, International Committee, or because of some international treaties that Singapore is a signatory of. So there may be a reason for you to be concerned with some of the other international bodies governing this particular topic. Okay? Now 4.3, very quickly, risk assessment. Now here there's something which I just want to highlight a little bit. Well, this is quite important as well. Now just look at the second line. This shall include a consolidated assessment of the financial advisors, AML, TFT risks that extend across all its business units, product lines, and delivery channels. Now, not only is it particular to a particular relationship or a particular transaction, here there's a guideline or even a notice provision to say that, look, the risk assessment, the risk-based approach, the risk-based assessment must be across the board of your company. All right, so it's called the enterprise-wide MLTF risk assessment. So it's across the whole financial advisor corporation. Right? All right, so A says that it requires a consolidated assessment of its enterprise-wide MLTF risk. Right? And 4.4 also talk about enterprise-wide. That means the whole company, across the company, different lines of businesses, different units, etc. Right? So to enable the financial advisor to better understand the overall vulnerability to MLTF risk and forms the basis of the FA's overall risk-based approach. Right? So it is the overall enterprise-wide based, risk-based approach. Right? 4.5 requires the financial advisor, board, and senior management to approve the enterprise-wide MLTF risk assessment and relevant business units, and to give full support to the active cooperation across the company's different lines of businesses. And 4.6 give you very detailed guidelines that you need to know a little bit about. In conducting enterprise-wide risk assessment, these broad MLTF risk factors that the financial advisor should consider include A, right? Slowly take your time, look at A, okay? In relation to customers, you are referring to the target customer markets and segments. Right? Are you talking about the private clients, the privileged clients? Are you talking about the retail clients? Right? And what kind of segments are you talking about? Right? So the customer market segment. Are you talking about collective investment schemes? Are you talking about capital market products? Are you talking about life insurance and so on? So that's the target customer markets and segments. Then profile and number of customers identified as higher risk. All right, so higher risk customers. Notably, you are talking about probably your politically exposed persons who are customers, or persons coming from higher risk jurisdictions, where FATF has mounted countermeasures, or it is well known that these countries do not have adequate measures or standards, right, in preventing money laundering and terrorism financing. And 3, the volumes and sizes of the customer transactions and funds transfers, considering the normal usual activities and the risk profile. So are there any differences in terms of the usual activities or the usual risk profiles? Right, so that is the enterprise-wide in relation to customers. Then B, say in relation to countries or jurisdictions its customers come from. Right, so this is to ensure that these customers are properly categorized. All right, so if they're exposed to its own activities or activities of its customers in these countries with higher levels of corruption, I'm sure some of you there may know which countries have a higher levels of corruption. All right, organized crimes, right, or inadequate AML CFT measures as identified by the FATF or other relevant institutions or bodies. Okay? So that's in relation to the jurisdiction that the customers are from or in. Right? And then, of course, the criteria, the guidelines given, how do you assess it? Okay? When assessing country risk and jurisdiction risk. So this guideline provides you the criteria that you may wish to consider. And this is evidence of adverse news or relevant public criticism of a country or jurisdiction. Right? So we all know certain countries are high in corruption. Right? FATF public documents on its website. Right? Independent and public assessment of a country's regime in terms of the AML and CFT regime or regulatory standards. And here they give us an example, FATF style regional bodies and mutual evaluation reports, the World Bank, and so on. Right? And then any laws and regulation standards of the country concerned, implementation standards. Right? Now, a country may have all the laws and the regulations in place, right? But the implementation standards may be lacking, right? So the standards are there, but if they don't follow the standards, then one has been more careful in this regard with customers from or in that particular country or jurisdiction. Okay? So it's the implementation standards that are of greater importance. Okay? Right? And I've said earlier before, whether the country is a member of an international group, there are meet countries or jurisdictions which meet certain requirements benchmark. So political stability, maturity, the sophistication of the regulatory and the supervisory regime, the level of corruption in the country, and so forth. Okay? So that's in terms of the countries and jurisdictions. Right? And then thirdly, under C there, in relation to the products, services, transaction, and delivery channels. Right? So not only must we be concerned with the customers, right? We also must be concerned with the jurisdictions that the customers come from or they are in. And thirdly, in relation to the products, the types of products and the services and the transaction and the delivery channels. Right? So these are all open again to AML and CFT regulations. Okay. Now 4.7 is self-explanatory, nature and complexity of your business. So if a giant FA or a giant financial institution, then it is required, right, that your enterprise-wide MLTL risk assessment framework should be larger and more sophisticated, right, depending on the number of employees, number of products, and where your customers are from or in. Okay, so now that's it. Then 4.8 tells you about the qualitative and quantitative analysis that are required. And yeah, and then 4.10, very quickly I move down the page there, risk weights to be given to individual factor or combination of factors, right? So you are looking at the customers, the customer segment, the profile, the country, and the type of products, services, and transaction. Again, you must attach weights to some of this, right? To enable you to have a better understanding what is the risk profile, okay, of your relationship or of the transaction concern, right? So again, I must repeat, it does not really apply to a particular customer or a particular transaction. The guideline here is for you, for the financial advisor, to have this enterprise-wide, right, to understand the overall vulnerability of the company, right, the vulnerability of the whole company in relation to ML and TF risks, right, because you are to adopt a risk-based approach. So what is the meaning of risk-based and how do you operationalize the risk-based approach, right? So the guideline there is very clear for you under paragraph 4, right? Paragraph 4, 4.1 all the way to 4.10, okay? 4.1 to 4.10, right? That gives you guidance, right, as to how you can put substance and put content into a risk-based approach. Right? It's easy for me to say, oh, risk-based approach, right? Or for the MAS to say risk-based approach. What does that mean? And how do you operate and implement a risk-based approach? All right? So in order for you to do that, the guidelines are given from paragraph 4.1 to paragraph 4.10. Right? The 10 paragraphs there also will help you to build up or to build up the overall enterprise wide-based risk approach. I hope that's clear. Now, in addition to the enterprise-wide MLTF risk assessment risk-based approach, there's also a need for you to be concerned with the next issue. This is the Singapore's National MLTF Assessment Report. I'll repeat that. Singapore's National MLTF Risk Assessment Report. Now this is in short form. The acronym is NRA, right? NRA, National Risk Assessment Report, the NRA. Now, the guideline for you in order to construct or to build, to formulate, right, the enterprise-wide MLTF risk management approach is for the financial advisor to incorporate the results of the Singapore's NRA report into your enterprise-wide MLTF risk investment process. All right, Singapore conducts the report, writes the report. So you are to incorporate that into your enterprise-wide MLTF risk assessment process. Now let me just read to you so that you can follow me. When performing the enterprise-wide assessment, a financial advisor should take into account any financial underlying or non-financial sector. Non-financial sector that's been identified as presenting higher MLTF risk. Right? I pause there for a while, let that sink in a little bit. Right? Financial or non-financial sector that's been identified as presenting higher MLTF risk. A financial advisor should consider the NRA results and enterprise-wide MLTF risk assessment results when assessing the MLTF risk presented by customers from specific sectors. All right? So here you are required, the financial advisor is required to incorporate the results of the NRA into your enterprise MLTF risk, right? In the effort to have a risk-based approach. Now, what does the NRA do? The NRA identifies certain prevailing crime rates as presenting higher MLTF risks. Right? So that's what, look at the NRA, if you have managed to have a copy of it. Look at the NRA, and it sets out certain crime types, right? And the financial advisor should consider these results when assessing its own enterprise-wide risk of products, services, transaction, and delivery channels. These are the qualitative assessments, and whether it is more susceptible, right? It is more susceptible to the higher risk prevailing crime rates. For example, tax evasion, right? Tax evasion is an identified crime rate, and this has become a very serious issue, right? Right? That's why in terms of the money laundering and transaction financing, right, they have included other serious offences. Right? You will recall it's corruption, drug trafficking, and other serious offences. So I have told you before that other serious offences, you have a very, very long list. Right? You can see from the schedule. But tax evasion is one of the key, right? So many people, right? Many people tend to evade taxes, right? Avoidance of taxes generally is considered illegal, right? But evasion of taxes is illegal, all right? And that is considered, the evaded taxes are considered criminal proceeds.